Welcome to the 2025-2026 Compliance Department Training, Protecting Students, Staff Reporting Obligations. This training is required for all school site and district office department staff. Our district remains under DOJ and California Attorney General oversight, and this year marks year 2 of the 5-year stipulated judgment. Today's session builds on the foundational training we completed last year. The California Department of Justice conducted an in-depth review of district practices. Among the most concerning issues the DOJ identified were critical and systemic failures in how the district responded to reports of sexual harassment, assault, and abuse. In many cases, complaints went unaddressed or were mishandled, creating long-term harm for students and eroding trust in the school system. They found violations of key laws and policies meant to protect students, including Title IX, which prohibits sex-based discrimination and harassment, CANRA, the Child Abuse and Neglect Reporting Act, Uniform Complaint Procedures, UCP, and other sections of the California Education Code. This reinforces why we're here today, to understand our responsibilities, close the gaps, and ensure our students are protected through consistent, lawful, and compassionate action. The district is legally bound to a minimum 5-year stipulated judgment for reforms, which include adding an Assistant Superintendent of Compliance, Dr. Rudy Wilson, revised board policies and administrative regulations, posters, and flyers, all district staff trainings, centralized tracking and response system for entering and tracking complaints and all compliance documents known as the Airtable. California DOJ reviews all of the submitted complaints and oversees the investigations. Compensatory education and mental health services to any victims. Climate surveys. School Climate Advisory Committee. And audits of all the above requirements. As part of our ongoing commitment to compliance and student safety, schools are required to conduct quarterly audits to ensure that policies are not just written, but actually visible and accessible through the campus. Here are the key items that must be checked every quarter. First, the district's sexual harassment policy must be clearly posted in the main office or another central area of the school. Second, there must be posters in every bathroom and locker room explaining students' rights and how to report sexual harassment. Third, policies that prohibit discrimination, harassment, intimidation, and bullying must be posted in visible areas, including classrooms, staff lounges, and meeting rooms, so everyone knows their rights and responsibilities. Fourth, we must post contact details for the Title IX coordinator, including their name or title, office address, email, and phone number. Students and staff need to know exactly where to go for help. Finally, a few important facility-based requirements to note are: no residential furniture should be in classrooms. It can give the wrong impression or suggest private, non-instructional space. And windows must remain unobstructed. This protects students and ensures visibility, except in emergencies. These audits help maintain a safe, compliant, and transparent learning environment. They are not optional. They're required by law and must be completed on schedule. In year 1, we made significant changes. We appointed Dr. Rudy Wilson as Assistant Superintendent of Compliance and Title IX Coordinator. Updated board policies on sexual harassment prevention, staff conduct, and student safety. Launched a centralized reporting system for complaints, aka Airtable. And delivered training and Title IX instructional videos to students across all grade levels, as well as provided training for staff and families. We have also conducted 2 school climate surveys and created a School Climate Advisory Committee, delivered compensatory education and mental health services to students impacted by past harm, and posted clear, translated notices at every school regarding non-discrimination and complaint procedures. We are now entering year 2, and our goals include adding more investigators and support staff, improving response and resolution timelines, expanding outreach so that families know their rights and how to report concerns, and monitoring progress through surveys, advisory meetings, and public updates. In today's training, we will cover Title IX, Uniform Complaint Procedures, or UCP, mandated reporting laws, including the California Child Abuse and Neglect Reporting Act, or CANRA, the Big Five responsibilities for all staff, and we'll review common scenarios and how to respond. Let's begin with Title IX. Title IX was enacted in 1972 and states, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance." The Title IX protects students and staff from sex-based discrimination in all aspects of educational programs. Title IX addresses several categories, including sex-based discrimination and harassment, which includes quid pro quo harassment, which is the conditioning of benefits or services based on participation in unwelcome sexual conduct. Hostile environment harassment, which limits a person's ability to participate in or benefit from an education program due to severe or pervasive, unwelcome, sex-based conduct. And other specific offenses including sexual assault, dating violence, domestic violence, and stalking. It also protects against discrimination related to pregnancy, parental status, and marital status. The Uniform Complaint Procedure is the district's formal process to handle complaints involving violations of state or federal laws. These often involve civil rights protections and educational equity. The Uniform Complaint Procedure guidelines for RUSD can be found in Board Policy 1312.3 and Administrative Regulation 1312.3. This slide outlines the types of complaints that fall under the Uniform Complaint Procedures, or UCP, as defined in RUSD Board Policy and Administrative Regulation 1312.3. Complaints under the UCP typically involve discrimination, harassment, intimidation, or bullying based on protected characteristics. This includes disability, gender identity, gender expression, or gender itself, nationality, national origin, or immigration status, race or ethnicity, religion, sexual orientation, bullying that targets students based on any of these protected categories, and importantly, boundary violations. UCP also applies to violations of state or federal laws involving educational programs, pupil fees, or concerns involving the district's local control and accountability plan. This chart illustrates the differences between Title IX and UCP complaints. Title IX follows the 2020 federal guidelines and focuses on discrimination on the basis of sex, or harassment based on sex. Complaints must be severe, pervasive, and reasonably offensive to meet the threshold for a Title IX complaint. UCP has a broader protection under California law and focuses on discrimination and bullying based on any protected class, along with boundary violations based on any protected class. UCP complaints do not need to meet the three-prong threshold, severe, pervasive, and reasonably offensive, to be investigated. Both pathways protect student rights, and your role is to report, not determine which pathway an incident falls under. Title IX and UCP incidents should both be submitted to the Compliance Airtable, investigated thoroughly, and documented in ARIES. They will both require providing supportive measures for those involved and clear communication with families. This graph is another visual representation of the differences between Title IX and UCP. Title IX has a narrower delineation based on federal guidelines and is focused on sexual harassment and sexual assault incidents. We are required to follow all district policies and regulations when conducting investigations. You can find these guidelines in Board Policy and Administrative Regulations 5145.71 for Title IX. The Uniform Complaint Procedures can be found in Board Policy and Administrative Regulation 1312.3. The Assistant Superintendent of Compliance, or legal counsel, will determine which procedures apply. Dr. Rudy Wilson is our Assistant Superintendent of Compliance. He serves as the Title IX and UCP coordinator. He is the primary manager of the centralized reporting system housed in Airtable, and he is responsible for coordinating compliance with the DOJ stipulated judgment. The first section of our training will review the district's responsibilities regarding complaints. This includes our collective district commitment, staff responsibilities, and the Big Five. The district is legally obligated to respond promptly, adequately, and impartially to all complaints, protect complainants, respondents, and witnesses from retaliation, and ensure fairness for all parties during the investigation. All district staff are expected to ensure these shared commitments are met. All district employees are responsible for identifying, reporting, and taking action to prevent and respond to incidents of sexual harassment, assault, and abuse, bullying of any kind, harassment or discrimination based on any protected class, and violations of professional boundaries as outlined in Board Policy 4019.1. These reports should be made to both site admin and compliance. It is our shared responsibility to make sure our students and staff are safe and to report when we see, hear, or sense a violation occurred. Every employee shall identify incidents, report to compliance and site or department admin, stop the behavior if safe to do so, prevent future incidents, and remedy the harm done. These are called the Big Five. It's important for every staff member to know these and follow these steps when they see, hear, or sense that something is concerning. Remember, identify, report, stop, prevent, and remedy. You may be wondering if your role requires you to report, and if so, do you report in every situation? Anyone who performs a school function, teachers, aides, custodians, SROs, office staff, bus drivers, coaches, contracted staff, are all required to report. If you work in our district, this expectation applies to you. Everyone has a responsibility to identify, report, and intervene. Complaints can be brought forward in a variety of ways. A complaint can be oral or written communication, or even an observation, which includes discrimination, harassment, retaliation, or intimidation. It could also include bullying or a boundary violation. The complaint can be made by students, parents, staff, or community members, and it can be made through email, social media, text, or in person. You must report incidents that happen both on and off campus, if they have a connection to school. This includes on-campus or at-school sponsored activities. Incidents can happen during school hours, on the way to or from school, or at after-school programs, or at athletic or club events. You must also report off-campus incidents if there is a school-related connection, or if it affects educational access. Remember, you do not need to have a special complaint form, identify the legal code the incident violated, or wait for a student to come forward. Just report what you see, hear, or sense. All Redlands Unified School District employees are mandated reporters under the California Child Abuse and Neglect Reporting Act, or CANRA. This means you are legally required to report any suspected physical abuse, emotional abuse, sexual abuse, or inappropriate physical or sexual contact. You cannot report to school district police or security department to satisfy CANRA. You must report directly to a legally designated agency, such as Child and Family Services or law enforcement. The agency cannot refuse your report. Take note of the contact name, time, and any instructions given. Let's break this down further. If the abuse or neglect happens on or off campus and you have reasonable suspicion, it must be reported to Child and Family Services, CFS. If the abuse is connected to a school setting, school program, or involves school staff, you must also notify law enforcement. A written report to CFS must follow within 36 hours. Here are some important phone numbers to have saved or posted in your workspace. San Bernardino CFS, Redlands Police Department, Highland Sheriff, Loma Linda Sheriff, Yucaipa Mentone Sheriff, and the San Bernardino Police Department. These numbers are listed on the mandatory district compliance posters. you will want to take note of which law enforcement office supports the area that the incident occurred within. Have these numbers ready when you're making a mandated report. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Even if CFS or law enforcement does not respond or chooses to take no action, the district still has a legal duty to promptly investigate and respond under education laws and district policy. We are not permitted to wait and see. Under Title IX, CANRA, and our own board policies, we must initiate our own investigation promptly, take any interim safety measures necessary, continue documenting and taking appropriate steps regardless of outside agency decisions. Even if law enforcement shares that they are closing the case or not pursuing charges, our duty to act remains. The legal standard for school action is not the same as the criminal standard. The safety and well-being of our students depends on our independent response. We are still required to take prompt and effective steps to investigate and resolve the concern. That means we don't wait for outside agencies before acting. We must stop, prevent, and remedy any harm or ongoing risk. And if a teacher resigns or retires during an investigation or disciplinary process, the superintendent may be required to report this to the California Commission on Teacher Credentialing within 30 days, per Ed Code 44030.5. We must also report under CANRA, California's mandated reporter law. In some cases, there may be additional required reports to the California Civil Rights Department, the Attorney General's Office, the U.S. Department of Education, particularly the Office for Civil Rights, and of course, to law enforcement for any suspected criminal activity. Bottom line, our legal duties are not optional, and they don't disappear if others decide not to act. We must meet our obligations to protect students and maintain compliance. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Let's review the Big Five, especially in the context of mandated reporting. Identify abuse, harassment, or boundary violations. Report to compliance and site administrator, and for CANRA, to the proper agencies. Stop the behavior when safe. Prevent future harm. And remedy the impact of what occurred. Every staff member shall follow this process. When in doubt, report. Let's now shift into how to report incidents and submit complaints. All concerns related to discrimination, harassment, bullying, or retaliation must be submitted through the Compliance Airtable system. This centralized system ensures timely follow-up, consistent investigation, and proper documentation. This is your direct link to the Compliance Office and Dr. Rudy Wilson. Anyone, students, staff, parents, community members, can submit a concern using the public Airtable portal. Take time to make sure you know how to direct students and families to the public link on our district website. Under Departments, select District Civil Rights and Compliance, and click File a Complaint. There's also a dedicated complaint form for staff. Log into the website using the Staff Login button and select the Staff Submissions button under the Title IX header. This form automatically captures your district email address when you submit the complaint. This is important for follow-up, as it allows compliance to contact you for additional information and confirms the source of the report. District employees should use the staff submission link when submitting complaints to the Airtable system. The more information you include, the better. This should include the names of students or staff involved, names of possible witnesses, dates and times of the incident, and a description of what occurred. Also, remember to pull information from ARIES when possible. Notify the student and/or parent that a submission is being filed. Use the student's name, not their ID number. And use the parent's email as the contact for the complaint. If the student cannot fill it out, staff are expected to assist. If you have questions or need assistance, please contact the compliance department. Let's clarify a few key terms. The complainant is the person harmed or making the complaint, usually the student. The respondent is the person accused of the conduct being investigated. And the reporting party is the person who submits the complaint, such as you, the staff member, in many cases. If you are submitting a complaint on someone's behalf, make sure the student or parent is aware and understands what's being submitted. This is a snapshot of the complaint submissions form. Items with a red asterisk are mandatory for submission. The form requires the complainant's first and last name, phone number, and email. This is often the parent's email when filing a complaint on behalf of a student. The nature of the complaint, the school or schools involved, and the date of the incident, and a section to describe the incident that led to the complaint. We'll see the remaining sections of the form on the next page. The form also asks if there were witnesses to the incident, whether an admin or supervisor is aware of the incident, and what your desired remedy is for the complaint. There is also a section to upload documents that are connected to the complaint. Gathering all pertinent information prior to submitting the complaint is helpful. Please review the directions at the top of the form and provide as much detail as possible. This slide reminds us of the difference between Title IX and UCP. But don't worry, you don't have to determine whether the complaint is Title IX or UCP. Just report. Dr. Wilson and the compliance team will assess the complaint and assign the correct investigation pathway. Your job is not to label. It's to report. This flowchart illustrates how the Airtable submission flows through the compliance process. First, the complaint is submitted through the Airtable system. Then the complaint is reviewed by Dr. Wilson. Dr. Wilson assigns next steps for follow-up, and a notification of rights and supportive measures is sent to both parties. Think of it like a ticketing system. When you report, it launches the entire response and compliance process, which is monitored by Dr. Wilson and the compliance team. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Time for another Big Five check-in. What do you do when something like Robin's report is shared? Identify the incident. Report to compliance and site administrator. Stop the behavior if it's safe. Prevent further incidents from happening. And remedy the impact on the student. This slide introduces our next module, Title IX. It will include definitions, common scenarios, and how to report sex-based harassment. We'll revisit Board Policy 5145.71 and go deeper into what qualifies as Title IX and how those complaints are processed. Let's define Title IX more specifically. According to the 2020 federal regulations, prohibited sexual harassment includes sexual assault, dating violence, domestic violence, and stalking. These forms of sex-based harassment are only considered Title IX violations when they meet all three criteria: severe, pervasive, and so objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. Title IX aligns with the Clery Act and the Violence Against Women Act. These laws ensure that institutions must respond to a broader range of gender-based violence and uphold students' civil rights. This applies not just in higher education, but in K-12 schools as well. That means both students and employees are protected under Title IX. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. As always, when any of these incidents are shared, the Big Five apply. Identify misconduct, report to compliance and a site administrator, stop the behavior if it's safe, prevent further incidents, and remedy harm to the student. We can't protect students if we're unsure what to do, so these 5 steps must become second nature. Next, we'll explore the Uniform Complaint Procedures, or UCP, which apply to civil rights violations and educational equity issues beyond the narrow Title IX scope. The UCP process is used to address discrimination, harassment, intimidation, or bullying based on a protected characteristic and violations of educational laws or policies, like requiring pupil fees for participation in school programs. Protected classes under UCP include disability, gender, gender identity, and gender expression, nationality, national origin and/or immigration status, race or ethnicity, religion, and sexual orientation, and boundary violations. Children have the right to equal access to education, free from barriers like intimidation or targeted harassment that can result in a loss of access to their education. UCP investigations can involve violations of state or federal laws, such as bilingual education requirements like English language development or ELD instruction, after-school programs, ensuring students have access to additional learning opportunities, language access for parents, ensuring they can fully understand communication from the school, support for specific student populations, such as foster youth, homeless students, students on an IEP or 504 plan, ensuring they will receive the necessary accommodations and supports, pupil fees, such as charges for test fees, field trips, and sports teams, the district's Local Control and Accountability Plan, or LCAP, which ensures that funding is used appropriately for student achievement, Williams complaints, which are specific complaints under the Williams case related to equitable access to instructional materials, safe facilities, and qualified teachers. It's important that we stay vigilant and ensure complaints related to these areas are handled through the UCP to remain compliant and protect the rights of all students. First and foremost, the law requires that discriminatory practices must be eliminated. Second, the law goes further by prohibiting not just overt discrimination, but also policies or practices that result in a discriminatory impact. As staff, it's our responsibility to be vigilant and proactive. If a policy or action might create barriers for any group of students, we are required to recognize it, address it, and ensure it doesn't continue. Harassment is often underreported, but its effects are serious. For students, this might look like decreased academic performance, increased dropout risk, and mental or physical health impacts. Schools and workspaces where discrimination goes unchecked tend to have lower overall academic achievement or work production, and a toxic climate and culture. Think about how your school or office tracks patterns of complaints. Are there trends being overlooked? Ensuring that we are proactively creating a safe, harassment-free environment for students and staff is important. 79% of public schools reported zero incident of sexual harassment or bullying in the 2015 to 2016 school year. Yet research from AAUW indicated that nearly half of students in grades 7 through 12 reported experiencing some sort of sexual harassment. It is our responsibility to make sure our students are safe when attending our schools and participating in school-sponsored activities. If you see something, hear something, or sense something, don't investigate. Report the concern and make an administrator or supervisor aware. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Once again, when facing any potential bullying, harassment, discrimination, or retaliation, your 5 responsibilities are: identify, report, stop, prevent, and remedy. Bullying is a key component of the UCP process. Every bullying complaint must be reported in the Airtable system. On the next few slides, we'll define bullying more clearly, including physical, verbal, social, and cyberbullying. Bullying is an aggressive behavior that involves a real or perceived imbalance of power between individuals with the intent to cause emotional or physical harm. Bullying can be digital, physical, verbal, or social relational. It can be one severe incident or repeated over time. Cyberbullying is included and defined by the electronic transmission of harmful content intended to humiliate, threaten, or discredit a student. Let's look at examples of prohibited conduct. Physical bullying can include hitting, kicking, tripping, taking personal belongings, and making cruel or rude gestures. Verbal bullying can include teasing or name-calling, inappropriate sexual comments, taunting, and threats to cause harm. These incidents often happen during unstructured time, so staff must be especially alert during transitions, recess, lunch, or passing periods. Bullying can also be social or relational, which includes purposefully excluding someone, spreading rumors, and public embarrassment. Or cyberbullying, which includes using texts, group chats, gaming platforms, or social media to share cruel or hateful content, spread rumors, impersonate or hack accounts, or publicly shame or humiliate someone using images or videos. Students are digital natives that are very skilled at using digital platforms. A non-employee may report bullying to a teacher, administrator, compliance officer, or any available school employee. Staff who receive a report of bullying must notify a site administrator within 1 business day. This applies whether or not a formal complaint is filed. You are obligated to act. Documentation, follow-up, and communication with the family must occur when a bullying report is received. If the bullying is based on a protected class, such as disability, race, gender identity, or sexual orientation, it must be immediately reported to the principal or administrator and to the Assistant Superintendent of Compliance, Dr. Rudy Wilson. All protected class-based bullying is investigated under the UCP. Even if a formal complaint isn't filed, the investigation must proceed. If the bullying is not based on a protected characteristic, the principal or designee will notify the complainant and take appropriate steps to resolve the issue. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Let's pause again to reinforce our process. Identify the concern. Report to the compliance and site administrator. Stop the behavior when safe. Prevent further harm. And remedy the impact on the student. Every district employee shares responsibility in protecting students from bullying in all its forms. Cybersexual bullying also includes dissemination of, solicitation of, or incitement to disseminate a photo or visual recording of a minor. If you discover or receive any nude, semi-nude, or sexually explicit images of a student, do not copy, save, or forward it. This may constitute child pornography. Instead, notify the police immediately and let them handle the evidence. In this section, we'll look at how to support students who have an IEP or 504 that are involved with the complaint process. We will review DOJ requirements and important facts to keep in mind when supporting students with disabilities. Students with disabilities are especially vulnerable to harm and are entitled to additional legal protections. Students with disabilities aged 12 and older are sexually assaulted at nearly triple the rate of the general population. Students with disabilities may be twice as likely to experience gender-based violence. The DOJ investigation found our district had systemic shortfalls in how we responded to complaints involving students with disabilities. We must do better. All students with disabilities have the same right to supportive measures. They cannot be denied services, classroom changes, or protective actions because they have an IEP or 504 plan. This includes changing class assignments, providing increased supervision, and offering mental health supports. IEP or disability status should never be a barrier to safety. When a student with a disability is involved in a disciplinary investigation that could lead to a change in their educational placement, the district is legally required to hold a manifestation determination meeting. A change in placement typically means a suspension of more than 10 consecutive school days, or multiple suspensions that add up to more than 10 days and show a pattern. The purpose of the manifestation meeting is to determine if the student's behavior was caused by or had a direct and substantial relation to their disability, or was the result of the school's failure to properly implement the IEP or 504 plan. If it's determined that the behavior was a manifestation of the student's disability, then the law requires the district to take supportive action, not just discipline. That includes conducting a functional behavioral assessment and developing or revising a behavioral intervention plan to support the student moving forward. This process is vital to protecting student rights and ensuring that discipline doesn't become discriminatory. In addition to holding a manifestation determination meeting when required, federal and state law also require that the school involve the student's IEP or 504 team during the entire complaint process, whether the student is the one bringing the complaint or is the subject of it. This collaboration ensures that the student's disability-related needs are considered at every step, and that they are not discriminated against in how the complaint is handled. Child find is a legal mandate under federal law that requires school districts to identify, locate, and evaluate all children with disabilities who may need special education or related services. This responsibility extends to all children, regardless of whether they're enrolled in public school, private school, or are homeless or wards of the state. Anyone, teachers, parents, or community members who suspects a child may have a disability should request an evaluation. And remember, the threshold to suspect a disability is intentionally low. It's better to inquire and rule it out than to miss a child who needs support. Services are available from birth through age 21 for eligible students. Any individual, whether it's a parent, guardian, or school employee, can request that a child be evaluated for special education services. If a parent or guardian makes a verbal request, it's our legal responsibility to assist them. We need to help them put that request in writing if they ask us to. When a teacher or staff member makes a referral, it needs to include 3 things: the reason for the referral, documentation of any general education supports that were attempted, and the outcome of those interventions. Once a request is made, either verbally or in writing, it triggers a 15-day timeline for the school to respond. That's 15 calendar days to provide an assessment plan or a reason for refusal. As school staff, we have a legal responsibility to ensure access to the complaint process for all individuals. That means if someone wants to file a complaint but cannot put it in writing due to a disability or illiteracy, we must help them. This is not optional. It's required under California regulations. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Retaliation is any negative action taken against someone because they reported harassment or discrimination, participated in an investigation, or advocated for someone else's rights. In this section, we'll review scenarios and how to report if retaliation occurs. Retaliation is prohibited under federal and state law. This includes Title VII of the Civil Rights Act and multiple board policies. These laws and policies protect students, staff, parents, and witnesses. If anyone is treated unfairly, intimidated, or threatened after making a report, it must be reported and addressed just like any other civil rights violation. RUSD board policy states, the district prohibits any form of retaliation against any individual who reports or participates in the reporting of unlawful discrimination, files or participates in the filing of a complaint, or investigates or participates in the investigation of a complaint or report alleging unlawful discrimination. Retaliation complaints must be investigated under the same policies and timelines as the original complaint, and resolved promptly and fairly. What this means in practice is, if someone reports bullying or discrimination and later gets bullied or punished for reporting, they are protected. If that retaliation happens, a new UCP or Title IX complaint must be filed and investigated. Think about how often students are called snitches after speaking up. That's retaliation, and it must be investigated and addressed. Pause the video now so the administrator or supervisor can read the scenario and facilitate a staff discussion using the questions on the slide. Even in cases of retaliation, your process remains the same. Identify what's happening, report to compliance and site administrator, stop the behavior if safe, prevent future harm, and remedy the impact. Now that we've covered what must be reported, let's focus on how it gets handled. In the next section, we'll review how to submit a report, what the district does with it, and how we follow through on our responsibilities under Title IX, UCP, and CANRA. All reports must be submitted to both the compliance office and your principal or site administrator. Methods of submission include online Airtable submission and email to compliance@redlands.k12.ca.us. If more than one staff member witnesses or is informed of the incident, make sure all are listed in the report and CC'd on the email. If no one receives confirmation within 24 hours, follow up or report again directly. If it involves suspected abuse or neglect, you must report it immediately under CANRA to child welfare or law enforcement. Then follow up in writing within 36 hours. As soon as a complaint is submitted, an automatic response email is sent to the complainant email that includes a link to the district's complaint procedures. This link includes information regarding UCP, Title IX, complaints concerning employees, and employee-to-employee sexual harassment. Note, if a staff member submitted the complaint on behalf of the student, you must forward this notice of rights to the parent or guardian and document on Airtable. After the complaint is submitted, the district must take immediate steps to intervene to stop the behavior, if safe to do so, and implement interim or supportive measures for the involved parties. Dr. Wilson's team will coordinate with site admin, special education teams, and others as needed to ensure support is appropriate and timely. Supportive actions must be offered to both the complainant and the respondent, followed up on, and documented. The site must confirm actions taken using Airtable and report back on any adjustments needed. Compliance will work with site administrators to determine the type of investigation. The parties involved, student, parent, or staff, must be informed of their rights, reminded there is to be no retaliation, and given the opportunity for informal resolution, except in cases involving sexual assault or staff-on-student misconduct. Informal resolution must be voluntary and documented. If not appropriate, a formal investigation begins, starting with a Notice of Allegations, or NOA. The district must investigate thoroughly, impartially, and without conflict of interest, and follow up with the complainant and respondent as needed. Is an informal resolution possible? This must be optional and voluntary with the ability to choose investigation at any time. Document choice, or document resolution not permitted for sexual assault and staff-on-student discrimination, harassment, or, if reasonable, risk that a party would feel compelled to participate. Issue findings and notify both parties of results, remedies or discipline, and retaliation protections and appeal rights. Follow up to confirm that the resolution was effective. Document everything in the centralized Airtable system. Organize and date notes, and clearly label the person conducting the interview in the interview notes. In most UCP cases, the superintendent will serve as the final decision maker. Supportive measures are proactive steps to help restore educational access and student safety. They must be prompt, non-disciplinary, free of charge, and coordinated by the site administrator in consultation with Dr. Wilson or a member of the compliance team. They can be offered to both complainants and respondents and must be tailored to individual needs and concerns. Some examples include counseling referrals, academic adjustments or deadline extensions, changing class schedules or seating assignments, restrictions on contact between students, increased monitoring or security support like hallway escorts, training, or academic supports. These supportive measures should be documented in Airtable and in ARIES, our student system. If you observe something concerning, or a student discloses something to you, your job is to report it, not to decide if it's serious enough. You cannot gatekeep. When in doubt, report. All reports must go to Compliance Airtable, or Dr. Wilson, the principal, and Law Enforcement, or CFS, if it falls under CANRA. This training reflects our district's ongoing commitment to student safety, equity, and compliance. We thank you for your time and attention. If you have any questions or concerns, please reach out directly to Dr. Rudy Wilson, Assistant Superintendent of Compliance, or any member of the compliance team at compliance@redlands.k12.ca.us. This concludes the 2025-2026 staff training on protecting students, staff report obligations. Please work with your site administrator or supervisor if you need support implementing these practices.